This is an appeal in the matter of Norton and the London Borough of Haringey.
My lords, I appear on behalf of the appellant, Mr. Thomas Norton, and my learned friend, Mr. Evans, appears on behalf of the respondent, London Borough of Haringey. My lords, this case is concerned with a discrete point of law which is identified as ground A in the grounds of appeal, namely whether lawful compliance with the assessment and planning duties contained in section 189A of the Housing Act 1996 is a condition precedent to a determination of the suitability of accommodation subsequently offered.
Yes, that's the point on which you got permission to appeal. Right. It's a hard-edged question of law.
It is.
We've read the reviewing officer's decision, we've read the judge's judgment, we've read the skeleton arguments, and we've looked at the authorities.
I'm very grateful for that indication, my lord. I can start then with the fact that that question has received some attention from the High Court in a case that we'll come to, in two cases, one YR and one UO, and we'll come to those in a moment. What the appellant says those cases establish is that a decision as to suitability based on an unlawful assessment will likewise be unlawful.
Yeah.
But the question...
That seems unexceptionable.
That seems unexceptional, yes.
I mean, if the section 189A assessment is flawed and it feeds into the suitability assessment, then the suitability assessment is going to be flawed. Well, that's not this case.
Yes. Yes, well, and that in essence is what I seek to persuade you is the law, yes.
Yeah, but that's not this case, is it?
It is this case because there is no 189A assessment prior to the decision, prior to the suitability assessment.
So there's no flaw. The decision is not based on a flawed section 189A assessment.
Well, the difficulty with that, my lord, is that that's not the view that His Honour Judge Saggerson took. His Honour Judge Saggerson took a different view in that what's termed the move-on assessment from November 2020 was sufficient compliance with section 189A. And whether as a way to avoid the hard-nosed question of law, or whether because he viewed that as being a lawful assessment and plan, it is unclear, but that's what he found, and that's why we end up here.
Well, is that within the scope of the appeal? I didn't think it was. I thought the scope of the appeal was simply the question, is an assessment under section 189A a condition precedent?
Yes, and that is the ground on which you, my lord, gave permission.
Yes. I didn't understand it to be said that Mr. Perdios' decision was based on a flawed assessment.
No, it's based on no assessment at all.
Yes, well, that's the position you're in.
Yeah, it is. And that's important because it was implied in the court below that that wasn't the case and that there was an assessment. But we proceed on the basis that there was no such assessment.
That's as I understand
it. Both of the parties are alive to the indication from the court to consider the impact on that issue, that question of law, of those authorities surrounding the evolving jurisprudence about substantial compliance with statutory duties and the mandatory and directory requirements. And I'll come to those in due course. We are alive to them. What I intend to do is to, because both the point of law and the wider question that the court's identified in relation to substantial compliance both require a fairly detailed analysis of the legislation. What I intend to do is to start with the law and take you through Part 7 and the authorities that have been decided on it, in the knowledge that you'll have some experience and knowledge of these matters. The essential legal scheme is set out in my skeleton argument at paragraphs 5 to 8, and a more detailed exposition of it can be found in the YR judgment, in the appeal bundle.
Sorry, which case?
It's in the authorities bundle. It's tab 3, page 123 of the authorities bundle,
Yeah.
And this is the case of YR and Lambert, reported 2023 Housing Roll Report 16, the decision of Mr. Paul Bowen, KC, sitting as a deputy. At paragraph 25, and I take it to this purpose, paragraphs 25 to 36, he sets out the law and what are termed the sequential duties that exist under the Housing Act, and he identifies them in certain ways, which I'll come to as we go along. But if I can take you back to the Act itself and to page 2 of the authorities bundle. This is part 7 of the Housing Act 96. Section 175 contains the definition of homelessness and threatened with homelessness.
Yeah. Nothing turns on that, does it?
Nothing turns on that, no, and you have it. Then if we go forward to page 14 of the authorities bundle, you have section 183, which is where the application for assistance arises, typing any degree to make an application. And I take you to this just for the definition of assistance under this part, because that can become relevant. So under subsection 2, assistance under this part means the benefit of any function under the following provisions of this part related to accommodation or assistance in obtaining accommodation. So thus, part 7 governs everything from initial application through all of the duties that are then owed and the functions of the local authority up until final discharge. Section 184 on the following page contains the first duty imposed on the local authority, and this is a duty of inquiry. And this arises where there's reason to believe an applicant may be homeless or threatened with homelessness. They're obliged to make inquiries and to notify the outcome of those inquiries, and you see that at subsection 3. The next duty is on section 188, page 21 of the authorities bundle. This is an important duty to provide interim accommodation pending those inquiries required by section 184, or in some circumstances pending a review. We don't need to get into that. And those are the first two duties, the duty of inquiry and the interim duty of accommodation, that are referred to as the sequential duties owed under the Act in most of the authorities. Prior to 2018, that's where the initial duties ended. There was nothing further that was required. The Homelessness Reduction Act, however, introduced new duties prior to determining what, if any, duty was owed. So if we then turn to page 26, section 189A, we need to look at this section in a little bit of detail, because this is the assessment and planning duty, and it contains two distinct duties, one of assessment and one of planning. Subsection 1 sets out when it arises. So this is when you're satisfied, not that you have reason to believe, when you're satisfied that the applicant is homeless or threatened with homeless and is eligible. And what the local authority is obliged to do in those circumstances is make an assessment of the claimant's case. And what an assessment is set out in subsection 2. And there's 3 limbs to it, 3 different assessments. So first, what's caused the applicant to be homeless? Second, the housing needs of the applicant, in particular, what accommodation would be suitable for the applicant, and any persons with whom the applicant resides, what reasonably be expected to reside. And 3, what support would be necessary for the applicant and any other relevant persons to be able to have and retain suitable accommodation. Subsection 3 imposes a duty to notify those assessments in writing to the applicant themselves. That is the assessment provisions, and that's the starting point for the early duties. The planning provisions commence at subsection 4. And once you've done that assessment, so the assessment comes first, once you've done the assessment, the authority must then try and agree with the applicant what steps the applicant is going to take to have and retain suitable accommodation, and what steps the local authority are going to take for that purpose. That agreement must be recorded in writing. If it's not agreed between the parties, it can be, in effect, imposed on the applicant by the local authority, indicating what steps they believe should be taken. Subsection 8 contains an obligation to provide a copy of that planning document, and that's what's referred to as the PHP, the Personalised Housing Plan, in the terminology of these things. Subsection 9 contains an important duty to keep both the assessments and the plan under review. And subsections 10 and 11 impose obligations to notify the applicant of any of those reviews. If we pause there a moment and ask why those assessments and plans are important, it's because they inform a number of the substantive duties to which will come in due course. And the courts have considered those duties, the lower courts, High Court. And you can see much of the judicial learning set out in the cases that we're going to come to of YR and UO. If for now we look at the decision in YR again, and tab 3, page 124, at paragraph 28.
Just pausing for a moment before we go there. If we look at 189B on page 28, that duty arises where the authority has satisfied the applicant is homeless and eligible. And subsection 2 requires the authority to take reasonable steps to help the applicant to secure that suitable accommodation becomes available.
Yes.
If you're right that section 189A assessment is a condition of precedent, there's nothing the local authority can do to comply with that duty before the assessment is made. Is that right?
Correct. And that comes from subsection 3. Yeah. Subsection 3 says, in deciding what steps they are to take, the authority must have regard to their assessment of the applicant's case.
And the same point arises under section 190.
Yes.
The local authority can't do anything at all, can't help the applicant without the assessment.
Correct. The analogy is often drawn with the Care Act. So if you think about the Care Act 2014, the Care Act, that has a very similar structure. You have a duty to assess need, then a duty to determine what services are to be provided in relation to that need. And what we would say is that the structure of this Act now, post 2017 Act, is very similar. It's the need that then informs the duty. So going to YR at paragraph 28, what the Deputy Judge does here is reference the evolution of the judicial learning on the assessment and planning duties. And halfway down paragraph 28, he makes reference to the decision of Clive Sheldon, as he then was, Deputy High Court Judge, in XY and Haringey. And he makes the observation that Mr. Sheldon emphasised that the initial assessment duty is clearly an important duty as it informs the nature of the accommodation that must be provided for the applicant, as well as her support needs to retain the accommodation. A lawful 189A assessment should set out the key needs, those that would provide the nuts and bolts for any offer of accommodation that does not have to deal with and set out every need that an applicant might possibly have. Once the assessment is complete, it must be notified in writing. So that's the initial starting point for the learning. At paragraph 33 of YR, the Deputy Judge again refers to the XY decision in the last sentence there, in terms of the duty to review that we just looked at under subsection 9 of 189A, and says that the duty to review is an important one as changes in the applicant's needs could affect the suitability of the accommodation offered to her, as is apparent from the case law at paragraph 36 below. And paragraph 36 deals with the question of suitability. I refer you to those two paragraphs in YR endorsing what was said in XY for the purpose of demonstrating that from the very first cases considering the assessment of planning duties, it was acknowledged that they are important duties that inform the subsequent discharge of duties. So they inform the suitability decisions. We've looked at section 189B and the circumstances in which that arises. And that's why we say it is sequential, these duties are sequential. The assessment and planning comes first. And it's only once you've done that that you get to the substantive duties under 189, well, not substantive, the duty under 189A to assist somebody to stop being homeless. Those 189B, or that 189B duty to provide or to take steps to assist a person to prevent their homelessness or to obtain accommodation, they're important for a number of reasons. And if we look at section 189B, page 28 of the authorities bundle, we can see why. As with other duties under Part 7, that duty continues until it ends in accordance with the terms of the section itself. And those circumstances are set out in subsection 7. Now, why is that important? Because it's only when that initial duty under 189B comes to an end that any of the substantive duties are owed. My Lord Justice Lewison took us a moment to go to section 190. And if we go to that now, page 30, you can see section 191C provides that duty to assist, to help, only arises once the 189B duty has come to an end. So the answer to my Lord's question is yes, the Act has built into it the fact that these duties are to be complied with sequentially, and the substantive help doesn't come until after the relief or the initial duty is over. You see that also in section 193, what's referred to as the main housing duty, page 35 of the authorities bundle. And again, it's subsection 1C. This section applies where the authority's duty to the applicant under section 189B has come to an end. So the substantive duties don't end until the initial duty. So they don't start until the initial duty has ended. The other reason why the 189B duty is important is because if an offer of accommodation is made at that point, or accommodation is made available at that point, so prior to any decision as to what duty is owed, that can cause the end of any duty at all. And you see that from section 193A, page 42 of the authorities bundle. So if an applicant is owed the 189B duty and he's made a final offer of accommodation or a final Part 6 offer, the distinction between the two is a final offer is in the private sector, a Part 6 offer is social housing from a registered social landlord or a local authority's own housing stock. And if they refuse that offer, the duty under 189B comes to an end. You see that subsection 2. But more significantly, the main housing duty under section 193 can never be owed. So these duties contained in 189B are of fundamental importance. That finds yet further expression if we go over the page to page 44 of the authorities bundle in section 193B. You'll recall that the 189B duty identifies steps that the local authority will take to assist an applicant. What 193B says is, subsection 2, Local authority may give notice to an applicant under this section if the authority consider that the applicant has deliberately and unreasonably refused to take any steps that the applicant has agreed to take under subsection 189A, that's the personal housing plan, or that was recorded in subsection 6B of that section, that's the imposing of the steps by the local authority. And what's the consequences of that? Well, if we go over the page again to page 46 of the authorities bundle, if that notice is served, then the duty under 189B comes to an end, and again, subsection 4, the section 193 duty does not apply. So if you just pause there and recap, what you have there is Parliament saying you go to the assessment duties. If you don't comply with the assessment and planning duties, if you don't comply with those, then the local authority will owe no further duty to you. The local authority will help you to find your own accommodation under 189B, but if you don't help yourself and you don't accept an offer of accommodation, then the duties will end to you. And what should be apparent from that analysis is the importance of that initial assessment, because that's the building block of everything. It's the assessment which informs the personalised housing plan. It's the assessment which informs the initial duty under 189B.
Now, subsection 6 seems to contemplate that the housing needs need not be identified in the assessment under 189A.
Where are you, Muller? Which section?
Section 193B, subsection 6. The purposes of subsections 2 and 5, in deciding whether a refusal by the applicant is unreasonable, the authority must have regard to the particular circumstances and needs of the applicant, whether identified in the authority's assessment under section 189A or not.
Yes, well that's because you could have a situation whereby there has been either a development, so for the most obvious example of that is the birth of a child or a child moving out. So that there might be a change of circumstances at that point, by that point. But the underlying principle is you have to have regard to the 189A assessment of need as your starting point. We've looked at section 193, which is the main housing duty. Might be worth looking at that briefly again. Page 35 of the authorities bundle. That's a duty, the substantive duties contained in subsection 2, which is for the local authority to secure that accommodation is available for occupation by the applicant. And in respect of any provision of accommodation, the local authority is required by sections 205 onwards, that's page 77 of the authorities bundle, to have regard to certain matters. So page 206 is of principal importance in this case. You can only discharge your housing functions, and housing functions include all the obligations to secure accommodation or to make sure accommodation is available for someone's occupation, only in the following ways. Either A, by securing that suitable accommodation provided by them is available, B, securing he obtains suitable accommodation from some other person, or B, giving him such advice and assistance as will secure that suitable accommodation is available for some other person. This is the concept of suitability, which is imposed by statute. Section, just for the benefit of completeness, section 210 contains some statutory considerations as to what amounts to suitability. So a local authority must have regard to parts 9 and 10 of the Housing Act 1985, slum clearance and overcrowding, and to parts 1 to 4 of the Housing Act 2004. That's the Act which introduces a number of different obligations in relation to licensing and management of residential premises. So management of houses in multiple occupation, for example. There's a considerable body of case on the question of suitability, which we don't need to get ourselves too bogged down in, because we could be here for a very long time if we did. There is a summary of the law in the YR decision at paragraph 36, page 126 of the authorities bundle. And it makes the well-known points that suitability is a flexible concept. It depends on how long you're going to be occupying it for, what duty you're owed when it's provided to you or made available to you, what your needs are, what the authorities or the availability of accommodation to the local authority and the local authority's resources, although we can query the relevance of that because of decisions of the Supreme Court. But for the purposes of today, that is the essence of suitability. It's not rocket science. In essence, a particular unit of accommodation must be suitable for the particular applicant. Most cases in recent times have turned on the issue of location. So you have the Supreme Court in Zella Mesa and Westminster giving guidance on how to deal with what's termed out-of-borough placements and so on and so forth.
Do the authorities say that the reason why a person became homeless is an essential factor in assessing what's suitable accommodation for them?
Not expressly, but it is implied. So, for example, if a person becomes homeless because they couldn't afford the rent, so they were living in they were employed, had a job, were paying the rent, lost the job, that would then feed into the question of affordability, because you couldn't then put them into an accommodation that was too expensive for them to live in. So it would provide a context, my lord. Yes.
So the reason I ask is that I think it's your submission that the assessment under section 189A, all of it, is a condition precedent to a lawful assessment of suitability.
Yes.
And one component of the section 189A assessment is the reason why the person became homeless in the first place, which isn't self-evidently an essential factor in deciding whether the particular accommodation is suitable for that particular person. It might be, or it might not.
It might be, or it might not, I think, is the answer, my lord, because it's more likely than not to be. So the principal reason why people are made homeless currently is the service of a Section 21 notice under the Housing Act 1988, which won't, I accept, will have little bearing on suitability. But where you're evicted...
It doesn't in this case, on the facts of this case, it seems to have nothing to do with it. And the points that are made about suitability...
It doesn't in this case, because, of course, Mr. Norton's... part of the reason of Mr. Norton being made homeless is the relationship breakdown and the need for him to have accommodation with his son, because he had a custody battle with his son, which required his son to come and live with him because his mother was unsuitable. So, yes and no, my lord, is the answer to that.
Thank you.
We probably ought to touch, or I ought to touch, on the reviews and appeals provisions in the Act as well. And there's section 202, page 67 of the authorities bundle. Not every decision is suitable to an internal review. Reviews were introduced to reduce the frequency with which people were making applications to the administrative court to challenge decisions. So the right of review was introduced by section 202 in 1996. Not every decision is subject to review. The most notable ones for our purposes are: you cannot review the terms of the assessment, you cannot review the plan that's produced under section 189A, you cannot review the steps that you are required to take under section 189B, whether by agreement or whether forced on you. What you can review is the steps that the local authority say they will take. You can request under 189B. That is the only way in which reviews come into these initial duties. And that feeds into the right of appeal to the county court, because the right of appeal to the county court, section 204, page 73 of the authorities bundle, that only applies if an applicant has requested a review. So if you don't have a right to review, you can't request a review, therefore you can't go to the county court. So you can't challenge your needs assessment or your personalised housing plan by way of review and appeal. That's the statutory scheme, and what the appellant says is that when it creates a series of duties that have to be performed in order. So you start with the duty of inquiry under section 184, you then have the duty of interim accommodation under 188, then you have the duty of assessment under 189A, then the duty of planning under 189A, then the initial duty to assist in finding accommodation 189B, and then the substantive duties to secure accommodation under sections 190 and 193. That's the graduated series of duties that has been referred to in much of the case law. It derives from a comment by Baroness Hale in Aways and Birmingham in the House back in about 2006. What then do the authorities say? And let's look at those in a little bit more detail. If we turn first to tab 3, page 111, which is the decision we've already looked at in passing in the Crown on the application of YR versus Lambeth. This case concerned a woman responsible for the care of 7 school-aged children. She applied to Lambeth as homeless, having lived in the area, and the children attending school there for over 5 years. And this may, my lord, provide something of an answer to your question about the circumstances of homelessness. Circumstances of her homelessness were that she was living quite happily in Lambeth, but then took responsibility for more children, so therefore needed larger accommodation. So the needs of homelessness, the cause of homelessness would therefore be relevant. The authority prepared what they referred to as a relief assessment and personalised housing plan, which purported to discharge the 189A duty, and the claimant protested that that assessment was unlawful, and the reasons why she did so are set out in paragraph 12 of the judgment. And they concern mainly the failure to acknowledge her need to live in Lambeth for the support and for the children's education. In discharge of the interim accommodation duty under section 188, the authority secured accommodation for her in Tilbury, in Essex, and she also protested that that accommodation was not suitable, principally because of its location. Having no right of internal review, as we've just looked at, she commenced judicial review proceedings, and the grounds are set out at paragraph 24, page 122 of the authorities bundle. As my Lord Justice Lewison pointed out at the beginning, the substance of it is ground, for today's purposes, is ground 3, or 3.1. The defendant was in breach of its continuing duty to provide suitable accommodation in the Lambeth area, in that, 1, the decision as to suitability, was based on unlawful 189A assessment and review. And what the at paragraphs, there's a long exegesis of the law, but we get to the substance of it at the substance of the decision at paragraph 79 onwards, page 137. At paragraphs 80 to 89, the Deputy Judge concludes that the original relief assessment and personalised housing plan were unlawful.
Well, the central reasoning is paragraph 80.
Yes.
Housing needs assessment and the PHP were unlawful.
Yes.
And he gives reasons for that.
Yes.
And then we go to 98.
Yes.
And he says the question is whether the decision on suitability was vitiated by the fact that it's based on an unlawful assessment.
Yes.
And he says it was.
He does.
And he gives some reasons for that too. And that's really all that's decided, isn't it?
It is. My Lord's ahead of me in the sections I was going to take you to. Say that there's one other I would take you to because it puts the sections in context. If we look at paragraph 83,
yeah,
this is acknowledging the point that a housing plan doesn't have to be drafted like a statute. But the important point that's made is halfway down. The question to ask is how a reasonable and sensible housing officer would understand what had been written. I accept I should adopt a benevolent approach and avoid being overly technical or nitpicking, but a hypothetical, reasonable and sensible housing officer considering this assessment of needs, which says that there is only a need for a 4 or 5 bedroom house, which was affordable and wished to be housed in Lambeth, would not be able to conclude whether the children's housing needs have been assessed and what those housing needs were, in particular what the impact of a move to a school would have been upon their welfare. The reason I refer you to that is because that goes to the heart of what the purpose of the assessment and planning is. Purpose of the assessment and planning duties, and the creating of the personalised housing plan, is to provide a document that any housing officer can pick up and can provide a cross-reference. So again, going back to the Care Act analogy, you can say, right, I have a unit of accommodation. Does that meet the needs that have been identified previously? And it's designed to create a greater degree of consistency and efficiency within housing management for homeless people. In terms of the paragraph that my Lord Justice Lewison took us to at paragraph 98 on page 145, he asks whether the unlawfulness of the 189A assessments and planning vitiated the decision, and he said it did for 2 reasons. And then he goes on to explore those 2 reasons at 99 and 101. At 99, he talks about the fact that 1881 accommodation was standalone, and he says about halfway down, the assessment of the claimant's housing needs, including the determination the property was suitable accommodation, was in fact based on the authority's 189A assessment. Test of suitability is identical whether 1881 is considered in isolation or in the light of the assessment under 189A. The extent the assessment under 189A was flawed, those flaws also undermine the 188 decision as a matter of both fact and law. It's immaterial whether it was a step taken under 189B. So the reason I refer you to that is because the court there is identifying that suitability and the concept of suitability, i.e. is what unit of accommodation is suitable for this applicant, is the same both at 189A stage and at this point where one comes to make the offer.
But it's implicit there, isn't it, that there can be an assessment of suitability under section 1881 separately from and in isolation from an assessment under section 189A. A local authority will always have to be satisfied that the accommodation is suitable. And what our case is that in order to do that, they have to understand the needs. But if they made an assessment...
Sorry,
I mean, doesn't it follow from your submission that if they made an assessment without regard to, or without having carried out a section 189A assessment, that would be unlawful whether or not it was in favour or against the applicant for housing?
Potentially, yes.
Yeah.
Yes. But in the same way, again, apologies for repeating the analogy, but in the same way as if someone was to provide somebody with 5 care calls a day under the Care Act when they only needed 1, that would be unlawful because the assessment of need hadn't been done properly to inform the decision. But the reality is that would never reach the courts because nobody really ever objects to an over-provision.
But it would still be unlawful.
It would still be unlawful. The second reason, still on the first reason of paragraph 100. The Deputy Judge talks about the position if it was in relation to 189B, if the accommodation was provided under 189B2. At 101, he also concludes that the decision was unlawful, the suitability decision was unlawful, because it was based upon the inquiries that they were obliged to cut. So it's an inquiries point that comes in at that point. The matter's revisited in the decision of UO and Redbridge. That's at tab 4, page 152.
What does this add?
What does this add? There's two comments which are important in the context of this case, which I'll take you to. To provide some context, it's very similar on its facts to the YR case. An applicant who applies as homeless has a fairly cursory assessment and plan, provided with accommodation in Peterborough rather than in Redbridge, and commences judicial review proceedings. And again argues that if the assessment and plan is flawed, then so is any decision as to suitability. And Mr. Justice Ritchie in this case finds at 112 that the defendant failed to lawfully or identify or assess the housing needs of the applicant and her children as required by 189A, and gives his reasons for doing so. And then goes on at 114, and this is the first of the paragraphs I wanted to take the court to. This meant that the assessment and plan did not lawfully consider what accommodation would be suitable for the claimant within the meaning of 189A. This in turn leads inexorably to the further conclusion that the RAPP was inadequately evidenced and reasoned. So it's the same point, my lord, I understand that. But what's being said there is that, in my submission, is that there's a distinction between if you don't, well, what's being said is if you don't assess suitability at the 189A stage, identify what is suitable at the 189A stage, you can't then go on later to identify what is suitable at the suitability.
Sorry, just
stage.
show me that again.
It's at 114. The assessment did not lawfully consider what accommodation would be suitable for the claimant within the meaning of 189A. This in turn leads inexorably to the further conclusion that the assessment is inadequately evidenced and reasoned. Finally, it is manifest that the defendant did not take any steps to agree or consult with the claimant on the PHP.
Where does that say you can't assess suitability?
It doesn't, but I'm saying it's implied from that.
Implied?
Right.
Because what the judge decides is at 131.
Yes, that's where I was going to next. And what's interesting about that, the observations that the judge makes there is this. He goes a little further than the deputy judge did in YR, because he says the defendant's decisions that the hotel accommodation and the Peterborough accommodation were in each case suitable, the pairs of 188 or 193, were made subsequent to and were based upon the defendant's flawed assessment and the defendant's failure lawfully to review that assessment under subsection 9 of that section, as well as the ongoing failure to conduct adequate inquiries and suitability assessments under 188, 193 and 189A. And what we say is that takes it a little further in terms of saying not just that because it's based on an unlawful assessment, but because there's been a failure to keep it under review. And we say, again, impliedly, what that is saying in that case is that there is an obligation to undertake the assessment first, to identify the need first. The UO Redbridge came back again. This is tab 6 of the authorities bundle. I'm not going to take you through it. Essentially, it's a rerun of the same arguments. But what I will take you to, and this is Dexter Dyer's case, he's sitting as a deputy. And this is the report at 2025 Housing Reports 2, page 201 of the authorities bundle. I take you to paragraph 97. This is considering the same argument about the castle being built on sand, essentially. And he says, if I step back and examine ground one as a whole, the defendant is correct in its first skeleton argument that a housing needs assessment is only part of the offer process and is designed to assist the local authority make an offer of suitable accommodation in accordance with its statutory housing duties. So we say that's another step along the path to saying that the housing needs assessment has to inform the suitability assessment, and by logical extension, the suitability assessment has to have regard to it. However, that cannot insulate an assessment from public law scrutiny. Indeed, given its pivotal importance in the offer process, it's essential that it's conducted and its conclusions reached in compliance with legal principle. If the argument is that the court can pass over flaws in the assessment process or not scrutinise carefully, I am not persuaded. The claimant submits that the assessment was unlawful. She is entitled to a decision from the court on whether it can withstand lawful, albeit benevolent, scrutiny. Now, that's said in the context of what was essentially an alternative remedy style argument that was being run. But for our purposes, it makes very clear that the assessment duty has to be complied with, and that it is of pivotal importance in the offer process. The same point is sort of hinted at again over the page, paragraph 102, where the deputy judge is talking about the inquiries failures that have occurred, and what he says is the significance of those failures is that no reasonable authority could be in a position to properly, that is lawfully, assess the claimant's housing needs and thus the claimant's priority for accommodation without making these reasonable inquiries and taking these factors into account. And again, we say that what comes out of that observation is that you have to have the housing needs assessment first. That if you don't, then you can't rationally conclude a decision on suitability. It's just while we have this decision open, it's perhaps useful to look at paragraph 153, where the court talks about relief and his observations in relation to it.
153?
Sorry, yes, it's paragraph 153, page 241. If we start actually at page 150, this is under a heading of disposal. To start off with, the Deputy Judge refers to Baroness Hale in and Zola Mazo as saying it must be clear from a decision that the proper consideration has been given to the relevant matters required by the Act and the Code. And we would say that's what influences the judge's decision, and indeed is relevant to this case because you have to have regard to the relevant matters, i.e. the assessment of need, the planning, before you get to the question of suitability. But I want to take to paragraph 153. Judicial restraint is a vital constitutional feature, and there's reference to the Miller case. But judicial vigilance remains essential to the rule of law when the life of the individual is materially affected by the decisions of public bodies. Yeah. This is not to make or usurp the defendant's merits decision, nor to intrude into policy formulation, which is none of the court's business, but to ensure that the defendant acts in compliance with the law. In each of the three impugned decisions, I judge that defendants falling far short of what Parliament envisaged. I raise that, we'll come back to it, because the reason it's relevant is because when we come to look at the alternative remedies, the substantial compliance arguments, that observation will become relevant, that there is a significant importance to the client, to the appellant.
But, I mean, if you go back to 108...
108. Yes.
What the claimant's saying is the initial offer of the Enfield property was based on an unlawful HNA.
Yes. That
was Mr. Olusola's assessment. And the judge says that 111 that Mr. Batterai not merely acknowledged Mr. Olusola's August assessment, but found it correct and placed reliance on it.
Yeah.
So having found that the assessment was flawed, the suitability decision was likewise flawed, and then he goes on at 113 to consider whether Mr. Batterai could have asked his own questions, i.e. not based himself on another assessment, but independently assessed the question of suitability by asking some more questions. So how does that show that the 189A assessment as a condition precedent, which seems to be contrary to the way the judge is approaching the case.
Because this is a question about the ground here is that the original, because what's said in this version of UO is that there was, under ground 2, is that there was a review of the circumstances of the case in April 2024, which itself was unlawful.
Yeah, but what the judge is saying at 112, for instance, the claimant is arguing that instead of there being an independent reassessment, i.e. by Mr. Batterai,
yes,
Mr. Batterai's assessment is closer to being confirmatory in nature.
yes.
And then he goes on to look at Mr. Batterai's analysis.
Yes. But Mr. Batterai, my lord, is conducting a review of the housing needs assessment, not a review of the suitability. That's ground 2. Where you get to the suitability assessment when you look at ground 3, paragraph 135 onwards. So what the judge is saying at paragraph 113 is entirely consistent with what I'm saying, is that you have to have the review of the housing needs assessment. That housing needs assessment cannot just be a cursory acceptance of a previous housing needs assessment. It has to be based on the officer's own investigations to inform the need, to inform the plan, to inform the steps to be taken.
But the reason why suitability failed was that it was based on a flawed housing needs assessment.
Yes, exactly.
Yeah. But the judge didn't say that followed inevitably. He followed a number of earlier judicial observations that it's hard to see how any other conclusion would be reached, but not that it was inevitable.
Yes, I have to accept, and do accept, I think I accept at the beginning when my Lord of Justice asked me, none of these cases expressly say there is a condition precedent to a suitability decision, which is the housing needs assessment. What I say is there is a building block to that route. That building block is, if you have an unlawful housing needs assessment, these authorities stand for the proposition that the suitability decision will fall.
If it's based on that assessment.
Not in every case, and I don't accept that they are only limited to that. The views of the Deputy District Judge in YR, Paul Bowen KC, and the views of Dexter Dice in UO, in my submission, go further than that, and go further to imply, certainly imply, that there is a housing needs assessment is a precondition.
Yeah.
And I accepted earlier on that it has to be implied from the passages I've taken you to.
Right.
Just while we're on UO, there is another observation that the judge in that case, deputy judge in that case, relied on, and was relied on in some of the previous cases, at page 130, sorry, paragraph 138, page 239.
Yes.
I just pause before we get to 139. In answer to my Lord's point about the implication aspect of it and whether or not it followed as night follows day, that if you have an unlawful assessment, you would also have an unlawful suitability decision. If you look at the quotation from Lord Justice Lane in UO number 1 at page 137, what he says, and indeed the Deputy Judge in YO number 2 accepts, is that grounds 3 and 4, i.e. suitability, are closely related to the question of housing needs. So it doesn't, he's not, we would say that supports our construction, that those two things are so intrinsically linked, and they're intrinsically linked because there are building blocks that aren't made up. Anyway, I was taking his paragraph 138. This is a reference to a much used quote of Mrs. Justice Lang in the SK and Windsor and Maidenhead decision, where she says, it's quoted there, if needs are incorrectly assessed, it is unlikely that the accommodation offered will meet the applicant's needs. Which that's another indication as to what we say. If you don't assess need, you can't have a suitability assessment.
Well, she says it's unlikely, not inevitable.
Yes, unlikely. But again, we say these things build. So, on the substance, the matter of principle, the hard-edged question of law, my Lord of Justice Lewison referred to, the appellant's case is therefore that any decision as to suitability has to be informed by a lawful assessment of need under 189A, such that an assessment becomes a condition precedent to such a finding. And the reason we say that is twofold. The intention of the Act and the intention of the Homelessness Reduction Act and the powers introduced by it is to create a document that will be the applicant's roadmap through their homelessness journey, updated as required, informing every decision that's made along the way, whether it's under 189B, 190, 193, or indeed from the local authority's point of view, 193B or 193C, and enabling any housing officer to pick up that document and understand the needs of the applicant. We accept that there may be urgent situations where an authority make accommodation available. So the applicant appears at 5 o'clock in the afternoon and says, I've just been thrown out, possibly as a consequence of domestic abuse, and therefore there is not time to do an assessment. But that,
if you're right on the hard-edged question of law, the authority can't do anything.
Well,
they can't say, well, you're going to be sleeping homeless on the street tonight, we'll put you up. No. They just can't do it because they haven't got an assessment on your case.
Well, Lord, they can, because you haven't, Section 189B duty, 189A duty isn't engaged, because the duty under 1888, as I pointed out earlier on, arises on the basis of reason to believe, and the 189A duty doesn't arise until you're satisfied of homelessness and eligibility. So the two are different. It's why I drew a distinction.
Right, so you say the local authority can provide emergency accommodation effectively under 188.
Yes.
And if they're actually satisfied, that encompasses that. The greater includes the lesser. If
yes, we have to have notification. The Act requires notification of every decision in writing. So it can't be done without that notification. My Lords, I don't intend to take you in detail as to how that, through the facts of this case, because as has been pointed out, it's a hard-edged question of law. I will just take you to a few documents which demonstrate in our submission why we're right. You have the summary of the facts which aren't in substantial dispute, set out in paragraphs 9 to 20 of my skeleton argument. But I'm now in the supplementary bundle. And as you'll be aware, this case has a very convoluted procedural history. There's been a trip to this court previously, there's been trips to the administrative court, there's been, I think, 3 homelessness appeals issued. But where we start is page 155 of the supplementary bundle. And we have to be careful with dates of these things because this is headed temporary accommodation move on assessment / PHP form. This document is dated the 26th of November 2020. I say that because it's very easy to be caught out by the effective date on the first page, but this is dated the 26th of November. And this is the only thing that exists in terms of a housing needs assessment and personal plan as at the date on which the review decision is taken. What's relevant is that that decision was challenged by way of judicial review as to being non-compliant with the legislation and being an unlawful plan. Those proceedings were compromised, and you see the order at page 193. You'll see there's a challenge to the failure to comply with the duties of assessment and planning, and then is settled on the basis of agreements by the defendant to review its assessment of the claimant's case, and thereafter prepare a revised housing needs assessment and personalised housing plan, and to provide the revised assessment and plan to the claimant solicitors by no later than 4 p.m. on the 28th of September 2023. That wasn't done, but I take you to that because what you have is, if not an express acceptance, then certainly the implication that there needs to be more done to the assessment that exists. What you do have then is the review decision, which my lords have indicated that they've read. But I would refer the court also to the emails at page 118 of the supplementary bundle. Now, these are emails made during the course of submissions on the review.
This is where your client solicitors are saying, well, where's the housing needs assessment in the PHP?
Exactly. And what is said in reply is on page 119 by the reviewing officer, Mr. Perdios, that a housing needs assessment was carried out in November 2022. That's the one I just took you to. Only 2 months before your client moved into his current accommodation.
But sorry, you said it was 2020.
Sorry, 2020. Yes, there isn't one.
So he says 22. That's a mistake.
That's a typographical error.
Yeah. Yeah.
And it's that response, because if we then go over the page to 120, there's a reply to that email from those instructing me, again emphasising the point that this hasn't been kept under review and is now out of date, and it's necessary, final sentence of the first paragraph, it's necessary for there to be a lawful updated housing needs assessment before a lawful decision can be made on the suitability review.
Sorry, I'm missing where that paragraph is.
Sorry, it's page 120 of the supplementary bundle.
Yeah.
The first paragraph, at the beginning, I refer to our correspondence. The last sentence, therefore it seems to us that.
Thank you very much.
And it's the consequence of that exchange that leads to, at page 123, the pre-action protocol letter to challenge the failure to comply with the assessment duty. And at page 131, last 2 paragraphs, those instructing me comment that the only 189A assessment and plan we've seen is the move-on assessment dated the 26th of November 2020, which was prepared well over 2 years ago. Pointed out at the time, it's provided to us that this assessment is not adequate to address a number of relevant matters. Then goes on in the next paragraph to talk about what matters had been raised since then, which include occupational therapy reports.
And was it this pre-action letter which led to the JR proceedings, which were compromised by the consent order you
showed? Yeah, I took the final order out of sequence, for which I apologise. But yes, this JR letter then leads to the judicial review being issued, which is then compromised in very short order. You can see the dates. It was the claim judicial review was filed on the 12th of September and it's compromised on the 25th of September.
Yes. Right.
What there is at page 164 of the supplementary bundle.
Okay, can you just help me?
Yes, of course.
Are you saying, obviously, if we go to the terms of the compromise at 193, that was on the basis that there was a failure acknowledged to carry out a 189A assessment, and the agreement was to to prepare a revised housing needs assessment under 189A.
Yes.
You say that was never done.
It was. I'll just comment. It wasn't done in accordance with that timetable. The document I'm about to take you to at page 164.
Yeah, it wasn't done before the reviewing officer
Wasn't
made
done
his
for the
decision.
exactly.
Oh, yes. In other words, it's the one that we see at page 164.
Correct.
Yeah.
Yeah.
Which is actually dated the 17th of November 2023.
Your challenge here is yes, all right.
Whereas our challenge here is to the
Is
review
to the
decision,
review, isn't it? Yeah.
which is dated the 3rd of October 2023.
Yeah.
So what we would say is that in the context of this case, applying the point of principle, we had made clear to the reviewing officer that you need, and to the local authority in general, you need to have the assessment of need, because there wasn't one.
Yeah.
But it was the most recent one was dated 2020.
And Mr. Perdios went ahead anyway and
Mr.
decided
Perdios went ahead anyway.
suitability.
And
Yeah.
we say he was wrong. These. I don't need to take you in any substance to the review decision letter, which is quite unusual on this sort of appeal, because obviously the focus is on that review decision, because the permission is limited to the discrete point of law. There is permission also to raise an inquiry's point insofar as it relates to the discrete point of law. There's not much to say about that. One follows from the other in my submission.
Well, if you've got to have a housing needs assessment as a condition precedent, you must make the inquiries.
Correct. Yes. My lord has it. Worthwhile taking you briefly to the decision of His Honour Judge Saggerson, which is at page 56 of the core bundle. And how he deals with this question. So, at paragraph 26 of his judgment, page 61, and I emphasise this isn't a conventional appeal from this decision, the focus is on the review decision, but this sort of informs why we're here. He sets out at paragraph 27 the essence of the law that I've taken you to, YR and UO, and then says at paragraph 28, Mr. Johnson submits that a PHP is mandatory, such as a precondition of a valid suitability adjudication is not open to respond to sidestep such a requirement to allow this without primary legislation. He then goes on at paragraph 29 to give reasons as to why he rejects that.
Well, we have read them.
Yes, the only reason I take you to it is for 2911, in that he finds that the decision, move on assessment form, he says dating from the 14th of March 2020, but he means the one we've looked at from November 2020, covers sufficient basis to qualify as a section 189A assessment, and that's not accepted by us. I just make that point.
Yeah.
So, if I'm right on the question of principle, and on the question of hard-nosed law, then the suitability decision of Mr. Perdios is unlawful because there has been no assessment of need. And it's there that the questions of substantial compliance, which the court alerted the bar's attention to last week, arise. Not least because there's one way of reading His Honour Judge Saggerson is that decision was substantive compliance. But the fact there was a housing needs assessment that existed was substantial compliance. Can I take you to those authorities which were in a supplementary authorities bundle that we filed? I'm going to go through them at some pace. The first of them is the Crown versus Sonergi. I hope I'm pronouncing that correctly. 2006 one appeal cases 340 found at tab 1 of the bundle. This case concerns the obligation in the technical application of the Proceeds of Crime Act from 2002 and in particular the obligation on the criminal courts in section 7 of that Act to consider how to act in respect of confiscation of the proceeds of crime. And section 72A contains a power to postpone making a determination regarding confiscation subject to a limit of 6 months unless there are exceptional circumstances. And the difficulty posed by that legislation is set out by Lord Steyne in paragraph 7. The question is whether or not the court is deprived of the power to make a confiscation order after the lapse of 6 months. In practice, it's been frequently thought to compel the result that the offender is free from the penalty of confiscation. The way in which that's approached was to look at the learning in relation to mandatory and directory requirements and ask whether that remained good law. At paragraph 23, having reviewed a number of authorities from the Australian High Court and Privy Council and so on and so forth, what Lord Steyne says is the rigid mandatory and directory distinction and its many artificial refinements have outlived their usefulness. Instead, the emphasis ought to be on the consequences of non-compliance and posing the question whether Parliament can fairly be taken to have intended total invalidity. On the facts of Sonergy, did the failure to comply with the procedural requirements of bringing the application within 6 months or determining the application for confiscation within 6 months have total invalidity and mean that it couldn't? The court said, no, it didn't. Of more use, perhaps, to this case is the decision in A1 Properties and Sunderland. That's tab 2.
Sorry, just if we pause at what Lord Steyne says here.
Yes.
Your case is that absent an assessment under 189A, everything else that follows is totally invalid. So if the reviewing officer makes a flawless decision on suitability, that's invalid.
That's correct. That is our case.
So the applicant applies as homeless. Local authority doesn't make the section 189 assessment. The local authority nevertheless assesses suitability and does so correctly. It then offers the applicant a suitable accommodation in accordance with its assessment, not its 189A assessment, but its independent assessment. Is that offer unlawful as well?
Yes, and that is Norton number 1.
And do you say Parliament must have intended that?
Well,
must have intended that if a local authority made a perfectly good offer of suitable accommodation to a homeless applicant, that is outside its powers because there is no section 189 assessment, 189A assessment.
Yes, but it has to be the case that the duties are followed in sequence. Otherwise, it has no meaning.
Yeah, quite. And that's, you say, Parliament can fairly be intended to have intended that.
Yes, I can, because you can put the example a different way. You can put the example in, for example, in relation to 189B duties, or indeed, let's not go to 189B, 189A. So in your personalised housing plan, you don't agree the steps that the local authority require you to take, so the local authority tell you what they're going to be. And the local authority say, you must go and see local estate agents in order to resolve your homelessness. And they haven't done their assessment before they've done your needs before they've done that. If they had have done your assessment of needs, they would have discovered that you don't speak English, so you can't go and talk to estate agents. The local authority then, without acknowledging that need, discharge their duty towards you because you haven't been to see any estate agent. There are hard-edged consequences at both extremes. And where this case exists is in the middle. So I accept what my lord is saying, that there can be what might seem to be absurd results at one end, in the example my lord gave, but at the other, there are equally absurd results.
Yeah, right. So he wants to go to A1.
Yes. This case concerns the failure by those seeking to exercise the right to manage to serve a notice of intention on a landlord, as required by the Commonwealth and Leasehold Reform Act 2002. Essentially, in managed blocks, you may well have several different landlords. The legislation says you must serve the notice on every landlord, or on the landlords. It wasn't served on what's referred to variously as the intermediate or the non-participating landlord. And it was common ground that that notice hadn't been served on a particular landlord inadvertently. The FTT, First Tier Tribunal, held that that error did not invalidate the claim. That decision is upheld by the Upper Tribunal, and there's a leapfrog appeal to the Supreme Court. It was also common ground, by reference to the decision of this court in Ellen Court, that the statute did not stipulate in terms what the effect of non-compliance with the notice, service of notice requirements would be, such that Parliament's tension had to be inferred. And you get that from paragraph 47 of the judgment. And here the Supreme Court is, I think it's Lord Briggs and Lord Sales giving the judgment. They quote my Lord Justice Lewison in the Ellen Court case as saying it's a melancholy fact that wherever Parliament lays down a detailed procedure for exercising a statutory right, people get the procedure wrong. And then it goes on to say at the end of that paragraph that the 2002 Act does not stipulate in terms what the effect of non-compliance with the notice provision should be, so Parliament's intention has to be inferred. What my Lord Justice Lewison was making a moment ago about the instant case.
Yeah.
At paragraph 58, what the Supreme Court endorsed is the view of Lord Stane that the correct approach to a failure to comply with a provision prescribing the doing of some act before a power was exercised was to ask whether it was a purpose of the legislature that an act done in breach of that provision should be invalid. Which again is the point that we were just discussing a moment ago. Then at the substance of paragraph 61 to 64, at paragraph 61, the point of adoption of the revised analytical framework in Sonergy was to move away from a rigid category-based approach to evaluating the consequence of a failure to comply with statutory procedural requirement, and to focus instead on A, the purpose served by the requirement as assessed in light of a detailed analysis of a particular statute, and B, the specific facts of the case having regard to whether any and what prejudice might be caused or whether any injustice might arise if the validity of the statutory process is affirmed, notwithstanding the breach of the procedural requirement. And at 62, this does not mean that the application of procedural rules in every statutory context turns on detailed examination of the consequences arising from the particular facts of the case, nor that a test of substantial compliance is properly to be applied in relation to every procedural rule. Examination of the purpose served by a particular statutory procedural rule may indicate that Parliament intended that it should operate strictly as a bright-line rule, so that any failure to comply with it invalidates the procedure which follows. An example under the Landlord and Tenant Act 1954, where failure to serve a notice in proper time means that a tenant loses their right to extend, procedural rules there apply in a context where there is an established bilateral relationship between landlord and tenant, where the tenant's in a position to know what clearly it has to do, where both parties need to know clearly what property rights they have and may dispose of in the subject, dispose of in the market. He then goes on to talk in paragraph 63, halfway down beside letter B, about the test of substantial compliance with a procedural rule may be an appropriate way to allow for such a balance to be struck between competing purposes. There's been substantial compliance with the rule. It may more readily be concluded that fulfilment of the competing substantive purpose of the legislation should be given priority. But we observe that reference to substantial compliance begs the question of what purpose is supposed to be served by the rule. And so the court goes on throughout its judgment to conclude that the failure to serve the notice on the intermediate landlord was not fatal and didn't invalidate the application to exercise the right to manage. And you get that from the final decision is that in R versus Leyden.
I think the point, the reason they came to that conclusion in A1 Properties was that the intermediate landlord had lost nothing of significance.
Yes, that's correct.
Yeah.
You get that from paragraph 87.
87, yeah.
Yes.
Yeah.
And then it's confirmed in 91. In 91.
Yes, it's 91 really.
91 is important. It's evaluated whether procedural failure has the effect of invalidating the process. The question to be addressed is whether a relevant party has been deprived of a significant opportunity to have their opposition to the making of an order to transfer the right to manage considered, having regard to what objections they could have raised, whether despite procedural omission they had in fact the opportunity to have those objections.
It's just above C. If there was no substantive objection they could have made, they've lost nothing of significance. Yeah.
We then go to the final case to which our attention was drawn, which is the R and Leyden case, 2025-2 Weekly Law Report 740. This case concerns, again it's a criminal case, concerns the procedural requirements relating to a retrial where conviction is quashed on appeal. Section 8.1 of the Criminal Appeal Act 1968 requires the defendant to be arraigned not less than 2 months from the date of the Court of Appeal's order for retrial. And the defendant wasn't so arraigned. There was a retrial, and he claimed that the failure to comply with the procedural rule meant that his retrial was invalid. The court noted at paragraph 66 the problem that we've seen from Sanjay through A1 Properties and to this case, which Lewison referred to earlier on, which is all statutes in which the Sanjay principle arise for consideration are likely to be expressed in mandatory terms. The problem is that the consequence of non-compliance with those mandatory requirements are not stated.
Is there a bit of backsliding to mandatory here? And I noticed that Lord Steyn talked about recurrent theme in the drafting of statute is that Parliament casts its command in imperative form, which is perhaps a broader expression than mandatory. Once the court in Sonergy had rejected the distinction between mandatory and directory.
Yes.
So perhaps we ought to substitute imperative.
Imperative. We can do that, my lord. At paragraph 76, what the court does is consider whether Parliament could fairly have been said to intend total invalidity to follow from non-compliance with the procedural requirements. And at 76 it says, in order to consider whether Parliament can fairly have intended total invalidity, it's necessary to identify the alternative to total invalidity. In most cases, the alternative will be an evaluation of the consequence of the procedural failure, whether any prejudice might be caused and whether any injustice might arise if the validity of the statutory process is affirmed, notwithstanding the breach of the procedural requirements. There's reference to...
Sorry, which paragraph are you
That's
reading?
paragraph 77.
77, yes. Yeah.
The court then goes on, paragraph 82, to adopt that approach and to find that there were built into legislation significant protections to a defendant who was tried, notwithstanding he wasn't arraigned within the 2-month period. And they set those out at paragraphs 82 and 83, find that that's the relevant alternative to which reference was just made in paragraph 77.
I think there'd been a concession, hadn't there, by the Crown that it would be a good ground of appeal against conviction.
Yes.
Yeah.
That's 80.
What can be drawn from those decisions is that a failure to comply with a mandatory procedural requirement will not necessarily invalidate the subsequent action, and that where Parliament imposes a procedural duty, for example in A1 to serve a notice on an invisible or intermediate landlord, the question is what Parliament intended the consequence of non-compliance to be. The starting point here is whether we're talking about the same issue. All of those cases are talking about procedural requirements. This, when one's talking about section 189A, that's not a procedural requirement. It's a substantive right, and that's the distinction that was drawn by Supreme Court Justice Briggs and Sales in A1 at paragraph 58. So if one deconstructs all of those cases, there's a procedural waypoint on the way to a substantive decision, to create a substantive right. So in A1, it's the substantive right to object. And in Sonergy, it's the substantive right not to have your property confiscated. And in Leyden, it's the right not to be retried if you're not arraigned.
You refer us to paragraph 58 of A1, and you've said that this is all about procedure.
Yeah.
That doesn't seem to be the way Lord Briggs and Lord Sales read it, because they say, as Lord Steyn held in his speech, the correct approach to a failure to comply with a provision prescribing the doing of some act before a power was exercised. They don't say it's a procedural provision. They just say it's a provision which prescribes doing something before exercising a power. Now, why doesn't section 189A fit into that description?
Well, I'll answer that question. They do then go on at paragraphs 61 to 62 to put it very much firmly by reference again to Lord Steyn and Sonergy to statutory procedural requirements.
Yes. And
they repeat that in paragraph 62. But here it's not The short answer is it's not a power, it's a duty. There's a duty to produce the assessment.
No,
you have a
sorry,
right to
no,
assess.
that's not right with respect. The provision prescribing the doing of some act is the provision prescribing the section 189A assessment. The doing of some act is the offer of assistance or the offer of accommodation or whatever follows. So in analytic terms, the requirement, the prescribed requirement is the section 189A assessment, and the power, the exercise of the power is then exercising, discharging one of the duties under the remaining provisions of the part 7.
Yes. Yeah, I don't necessarily disagree with that. The point I'm making is that the context in which these have been examined
are procedural.
They're
Yes, I understand
not
that.
substantive. And that's why I took you to those observations in UO that might have seemed irrelevant, which were about the enforceable rights that were created by section 189A, and how you had the applicant had the right to challenge those. That's paragraph 97 of UO2. It also why I took you to the consequences of, within the statute, of not complying with the duty. So the consequence of not complying with the not assessing need is that you can't then have a plan, but failure to comply with the plan, if it's created without an assessment of need, can result in no duty being owed to you at all.
Sorry, so just say that again. The consequence of not assessing needs means you can't produce a plan.
Yes.
And that means no duty arises.
Yes, because if you... I took you through the legislation earlier. If you don't have an assessment of need, or a personalised housing plan, the steps that you then take under 189B are not informed by anything. They're just freestanding steps that the local authority devise. The consequence of that can be that you don't comply with those steps, potentially because you can't, in the example I gave earlier on, and therefore all duties to you under Part 7 cease. That's the effect of 193A, 193B and 193C. And likewise, if the plan you do create is not lawful, because it's not based on a housing needs assessment, you can nevertheless have your duty discharged for not taking the steps that are identified in a plan which doesn't take into account your need.
Wouldn't it be an unlawful decision in itself? Wouldn't automatically follow, surely, that it was discharged under one of those provisions?
Well, potentially, yes, my lord, but that's why, but not if the role of 189A is reduced by saying it doesn't matter. It only becomes something challengeable if you accept that the assessment of that the requirement to assess and to plan is the first step and is a condition precedent to everything else. So, if you don't, sorry, my lord, if you don't accept that, then there isn't any illegality, because then a local authority could attend any judicial review that there was of a decision and say, yes, we didn't produce a housing needs assessment, we didn't produce a plan, but that doesn't matter because it's not a condition precedent to any of our other decisions. You're stripping 189A of any purpose on the other. Sorry, my lord, I interrupted you.
But it would mean, wouldn't it, that let us suppose the local authority produce a housing needs assessment, and on the basis of that they offer accommodation. The applicant asks for a review and says to the reviewing officer, this housing needs assessment was flawed because it failed to take into account the fact that I'm disabled. And the reviewing officer says, you're quite right about that. So I will reassess suitability, and I decide that what the local authority offered you is not suitable. You say you can't do that?
We would say that that puts the cart before the horse, and that what the reviewing officer should do is say, you're right, your assessment of your needs was wrong. We did not identify that you were disabled, my lord's example. I've amended, I've reviewed, as I'm statutorily required to do, because you've now told me you're disabled. I've reviewed your housing needs assessment. That now records that you're disabled, and applying that, I find this property is not suitable.
Yeah.
Now that raises a question as to whether or not. No, it doesn't raise that question. So the answer to my lord's question is procedurally, what needs to happen is that the housing needs assessment needs to be rewritten. And the example my lord gives is a good one, because, and indeed is what happens in this case, because what you would have is you would have a housing needs assessment that did not identify disability. And as we've seen, the purpose of that assessment and plan is to be something that anybody can pick up and understand what it is that the applicant needs. You then have a suitability decision, which says, I find this accommodation is not suitable for you because you're disabled, even though the housing needs assessment doesn't refer to you as being disabled. So the next housing officer who comes along to allocate accommodation picks up the housing needs assessment and offers them accommodation that's not adapted again, as you end up in a perpetual cycle. The purpose of the legislation is to avoid that happening.
Yeah.
It's for the benefit of applicants. It's to make sure that, and to a certain extent, the benefit of local authorities, that they're not wasting their time by making offers of accommodation to people when they can't accept it. So the answer to my lord's question is, no, the reviewing officer couldn't do that, because what the reviewing officer would need to do is to revise the housing needs assessment and PHP prior to making their decision on suitability.
Yeah.
Or in the case such as this, where it's an outsourced reviewing officer, to say to the local authority, your housing needs assessment appears to be wrong, you need to redo it. Here is what I've discovered from my inquiries. You need to amend the housing needs assessment, and this is the decision I'm minded to make. And that fits in with the legislation, because you can make the minded to decision. The minded to decision would then enable you to redo which is what's done in this case, would enable you to then redo the housing needs assessment, and then enable you to do your decision of suitability.
Yeah.
It's not an onerous task, it's what the legislation demands. But what we would say is that this case is closer to the type of bright line rule that was talked about by Lord Justice Briggs and Lord Briggs and Lord Sales in when they're referring to the Land on Tenant Act 1954.
Yeah.
And why do we say that? Well, we say because what you lose, potentially, by not having your housing needs properly assessed prior to a decision of suitability, are an awful lot of valuable information, the opportunity to make submissions and to make representations into relation to that. And that's not just as with the 54 Act, whereas if you don't serve the notice in time, you can't renew your commercial tenancy.
Well, I mean, you have the opportunity to make submissions on the review.
You do, but that then gets very complicated, my lord, because what if you accept the property? If if you accept the property, the law says that the review is based on the facts as they existed at the date on which you accepted it. So you can't make any further submissions. There's a distinction. It's a case called Mohammed and Hammersmith and Fulham, which says that if you're a review of suitability, if you accept the accommodation, is based on the facts as they exist as at the date of the review. If you refuse the accommodation, it's based on the date of refusal. So I refuse the accommodation because it's manifestly unsuitable for my needs because I can't access it, but the local authority didn't know that because it's not in my housing needs assessment. I then say to the reviewing officer, I refused it because it was unsuitable for me, and he says, well, we didn't know that. So you can't make those submissions.
Why not? I don't understand why not.
Because it's the assessment of suitability is based on the circumstances as they exist at the date of the offer, not as they exist at the date of the review, where you've refused the accommodation.
Is knowledge one of those circumstances? I can see why the actual circumstances are those that apply at that date, but what the authority knows or doesn't know about them doesn't necessarily come within the scope of that.
That becomes a very difficult question, my lord. A very difficult question indeed, because once you crack open that seal, and once you say, well, House of Lords are wrong in Mohammed, and in actual fact, you can have regard to circumstances you didn't know about, then you're into the territory of, well, what else do you take into account? If I then put in a report from my child's school saying they have to be within 2 miles of the school, otherwise their academic attainment will fail. It becomes a very difficult question. But the point for these purposes is you can avoid it if you have to have had your housing needs assessment first, because your housing needs assessment will be informing the decision on suitability. The other, sorry, excuse me. There's some support for this proposition in the Code of Guidance. Can I take you to the last tab in the Authorities Bundle, tab 7? This is chapter 11 of the Homelessness Code of Guidance for local authorities.
Yeah. Yeah, they clearly recognise it's an important document.
Recognises it's an important document.
Yeah, paragraph 11.2.
11.2. Yes. But also 11.1. Again, you have the imperative terms in paragraph 11.1. Must carry out to determine the duties owed to a person.
Yeah.
But that phrase is important because that phrase takes it beyond what the statute says and supports what we're saying. The assessment must be done to determine the duties owed. And that supports our analysis that when you're conducting this assessment, it's to inform every duty that then follows on. And if that's right, then it must be done first. It must be the first building block on which you base your consideration of a homeless application. And that finds further expression in 11.2, where it talks about, in the language of these things, it talks about providing a framework for housing authorities and applicants to work together to identify appropriate actions to prevent or relieve the applicant's homelessness. The whole point is, these duties are there to enable applicants and local authorities to work together. So, my lords, what we would say is, to start with, the structure of the Act creates sequential duties that have to be performed in order. And if you don't perform those duties in order, where the chain is broken, everything else that follows from it also falls. So if you don't produce your needs assessment, you can't produce your plan, you can't produce your, you can't discharge the initial duty, and you can't make a decision on suitability. That, we say, comes by extension from the authorities that already exist on section 189A. If you accept that as a principle, the only question then becomes whether or not that survives the treatment of imperative terms by the House of Lords and the Supreme Court in Sonjay, A1 and Leyden. Well, we'd say it does, because this is not a procedural rule that's not being complied with. This is a substantive right, CUO. And that what you can say is that Parliament did intend that this comes first, and that if you don't comply with it, what you end up with is total invalidity.
Yeah.
My lords, there, if I can turn my back briefly just a minute.
Sure.
No, they are the submissions on behalf of the entire. If there's any questions.
Yeah, we'll just rise for a couple of minutes, see where we go from here. Please don't leave the courtroom.
All rise, people.
Yeah, I don't think you're. But then again,
may not trouble you.
yeah. Then again, they didn't trouble Catherine Rowlands in the zone of Mazer.
Well, I had Terry Everton once, and he said, "I need trouble you." I said, "Yeah, you're right now. Totally blitzed." That was
I don't know that's happening today.
That was the case. But it's received a lot of criticism. That's to do with adverse possession under the 2002 language. There's some get out for the adverse possessor if they have reason to believe the land belongs to them. And in the case that I had, the documents were there on the land registry files. Solicitors didn't bother to pull up a lease that's mentioned in the land registry titles, and that made it clear that the land didn't belong, could never belong. But Terry Everton said it's a subjective belief, reasonable to believe. The buyer doesn't have to rely on their solicitors making adequate inquiry. And your stuff, Mr. Evans, and the client didn't understand it. But it was worth about $1 million.
Did I read?
Peckham, High Street.
Did I read that he'd died?
Yeah, you did. They're all dying. All these people that we used to
All the
know.
nice ones.
Has he been kind to you?
No, but I always found him a decent.
Yeah,
tribunal.
quite. Yeah, I know. Yeah.
I mean, you got a fair hearing. He could be rough.
Well, Terry would have been up. You had the right judge.
I stood there in front of him.
All rise, people.
Well, thank you very much, Mr. Johnson, for your interesting argument. Mr. Evans, we don't need to trouble you. We will in due course dismiss the appeal for reasons to be given in writing. You will get a draft judgment in the usual course. That will come with a fierce embargo, which means what it says. It will be your opportunity to correct our English but not our reasoning, and we would hope that in the light of the draft judgments you will be able to agree and order disposing of the appeal. If you can't agree in form of order, please make short written submissions, and we will make the order we consider to be appropriate. Thank you very much.
All rise, people.